listening. Let's take a few questions. Yes, ma'am.
If you have all your end-of-life documents done, and then you move to another state, do you pretty much need to have someone look at them again?
Lady asked, if you go to a different state, you've had your documents in place, should you have them looked at? My answer is yes, because if you move to a state like Louisiana, they follow French civil law. You move to Texas, they have a community spouse law. You go to Florida, your healthcare directive and power of attorney may not work because they require a different way of executing. With most of my snowbird clients, I have them execute both Florida and Maryland healthcare and power of attorney. Yes, ma'am.
Where do you store your power of attorney?
That's a very good question. Where do you store any document? Your power of attorney, I always like to keep one. And I put in the document that photocopies and facsimiles and the like and digital type of documents are deemed to be originals. Number two, you want to keep them readily available because a healthcare problem can occur at 2 at night. I keep a healthcare directive in the glove compartment of my car and in a suitcase when I travel.
Okay.
Number two, I keep one in my house. My daughter has a copy of my documents, and I'm my own lawyer, but my law firm has it. Now, let me share an example of a problem I had. I was traveling last spring, and I was in Vancouver, and I was bouncing checks about as high as the ceiling, and I thought I was in great shape. So it happened that something got fouled up, and the check went into the wrong account. I have multiple accounts. So what did I do? I got on the phone, called my daughter, said go to the law firm, get my power of attorney. I called the bank, my daughter's coming up, she backed it out, end of problem. So you need those. You don't want it locked in a safe deposit box because what if you have a problem at 4 in the afternoon and the bank's closed? Other questions? Yes, ma'am.
What do you feel about I guess it's a revocable will?
Young lady asked a very good question. There's a tool called a Revocable Living Trust that many of us use for estate planning. I use them in certain cases. One, if people have enough assets, usually $500,000 or more. Two, if they have assets in multiple states. Why multiple states? Because otherwise you have to open probate here, Delaware, and Florida. You just have to look at your assets. If most of your assets are a retirement plan, a house, bank accounts, you probably don't need it. But you should assess that. A lot of lawyers were running around doing seminars. Everybody needs revocable trust. The answer is you all need a healthcare directive, you all need a power of attorney. You all should have a will. If you use a revocable trust, the will is very simple. Not everybody needs that trust. It doesn't really help you tax-wise beyond what a will do. I can take one more question. Yes, ma'am.
Around what age should long-term care insurance be purchased?
Young lady asked, of what age should you consider long-term care insurance? Somewhere between 45 and 60. Why? Because of insurability. If you have an illness where you can't secure it, then you're precluded from getting the coverage. I believe that you should look at all your insurance and say what's important. If your kids have been educated, life insurance becomes a little less important. Your house is paid off, life insurance is a little less important. You age, disability insurance is less important. To me, as I age, my big fear is long-term care. I bought a policy that was $175 per day, 4 years of coverage. Had my wife been eligible, I would have gotten her probably each of us 3 years. And I have an inflation factor. That is the key, because in 20 years or 10 years, $175 a day may pay for us to go to McDonald's. You know, it may not give us the money that we need. So that inflation is critical. One last question.
The will and the power of attorney. Does both husband and wife should be, or have to have the consent to assign somebody?
The gentleman asked, when you do a will and a power of attorney, first of all, should both spouses have it? The answer is yes. The second question is, who should you name in those documents? Well, I usually name as the fiduciary the spouse. The exception would be, what if we have a second marriage and I've only been married for a year? Then I may want my kids. In some cases, we want to check and balance. Child from column A, first marriage. Child from column B, second marriage. And spouse. I mean, that's where the dynamics of all these cases, it always takes you back to getting to know the family. You got to know the dynamics. You got to know how they get along. You've got to anticipate family feuds. I mean, we have a whole group. We have 12 people in my firm that I call family-centered practice. I have about half of one guy's time is all about family feuds, going to court and things like that. That can all be avoided by well-thought-out planning, I promise you.